The evolution, that too revolutionary evolution that has occurred in the American judicial system has not occurred in our country even after a very long time. That is the surprising thing, because we have been following procedure established by law. No question of DPL. See, let's take one example, one case, study case law, A.K. Gopalan versus State of Madras. In this case, what happened? A.K. Gopalan has been in jail for 3 years, 1947 to 50, and again after release in 1950, he, being a communist, he attended one meeting and made some derogatory, some objectionable expressions used. Because of that, again he was arrested under PD Act, Preventive Detention Act, and he filed a petition in the court, High Court, and that case was brought to Supreme Court. Finally, the Chief Justice, the first Chief Justice of India at that time, Harilal Kanya, he pronounced the judgment in a very different way, following the PEL, procedure established by law. There, what he said is the action of the government, state government, and the High Court has been correct, because they followed the provisions of the Act, provisions of the law. Here, PD Act, Section 14, and all that, right? So there is no question of anything wrong in this case. So that's what they said. And for the first time in 1978, that means a very long time of 28 years, for the first time in Maneka Gandhi's case, Maneka Gandhi versus Union of India, in that case, her passport was confiscated and she was prevented from going abroad. Then she filed a case in the court of law. Here, what he applied here, that triangle, golden triangle, that is Article 14, equality, and 19, that is the freedom of movement and expression, speech, and Article 21, there it was subsided. But here, for the first time, it was considered under due process of law. And for the first time, Article 21 has been given a lot of importance. It was expanded under this due process of law. And what is just, what is right, we have to follow. For the first time, they followed the justice in a just and fair model, without not being arbitrary, without being arbitrary. And justice was done in favor of Maneka Gandhi, because they followed due process of law. What is the main concept of this act, and what is the provision in that passport act? They studied very closely what that act says, whether it is in consonance with the whether it is consonance with, means according to the constitution or not. If it is not against constitution, what is the thing to be done? How the human rights and fundamental rights are to be protected? From that angle, they have seen, studied for the first time, following this principle, legal duality, and then favorably it was decided. And after that, even after a very long time, again there was a lot of gap, and then latest cases, during some latest cases also are in favor of that due process of law. Some of the cases I would like to explain here. Satish alias Chand versus Uttar Pradesh. It was decided in 2024. The case is about Pakso. So the boy and girl both were taken to task. The boy was arrested, imprisoned, and bail was not granted. The case came to the Supreme Court, and there the Supreme Court decided, no, it is not fair on the part of the lower courts. See, POXO's main aim is, the legislative intention is to protect the teenagers, adolescents, but instead of protecting them, they are being taken to task unnecessarily, because the essence of the act they are not observing. The due process of law, what is the aim of that law, what is the intent of that act, you have to observe. When there is a consensuous relationship between the two partners, boy and girl, there is a consensuous relationship between these two, so we have to encourage them. They must be married. There is no question of any punishment. So that kind of judgment was given in this case. Whereas in another one, dear Jagdish Prasad versus Bihar, and another case, Net City Systems Right Limited versus Delhi NCT. In these two cases also, the issue is about bail and anticipatory bail. When anticipatory bail is to be sanctioned, issued, only when the lower court studied it, Sessions Court, a district court, when the lower court studied it thoroughly, because it is the lower court, they can study the case very clearly. Investigation by the judge, investigation by the police officer, investigation by the related persons, then only they come to the conclusion whether the person is eligible or not, and what are the circumstances that have led that person to seek that anticipatory bail and all that. So directly, as per the provision of the law, directly filing the petition for the anticipatory bail in the court of High Court or Supreme Court is not fair. That is a blind procedure, he said. So DPL has been observed there. And in another case, Jagdish Prasad versus the state of Chhattisgarh, a very surprising case this is. And that is, one government servant took some bribe, 100 rupees bribe. It happened in 1986. And afterwards, he was arrested, imprisoned, and apart from a fine of 1000 rupees. The case went on and went on for a long time, 39 years, and the judgment was delivered only in 2025, September 9. So here also, in these previous cases also, September 25, after 2-3 years, 4 years trial. Here, 39 years, from 1986 to 25. So what is the actual, that Corruption Act 10, Section 3, what it says? You have to study it very clearly. Here, they blindly, according to Section 6 of the POCSO Act, he was arrested. Other things were not considered. And here, blindly they studied Section 10 of 3 of 10 and subsection 3 of the Corruption Act. And in what circumstances he has taken, whether there is an acceptance, whether there is a demand, and after taking the bribe, what are the circumstances? So these are the things to be corroborated with each other, one another. So under this due process of law, that has not been studied. That is the reason why it took 39 years, completely 39 years. So what are the things to be noted here is that either DPL or DPL, in either of these things, see the dual legal duality, because of the legal duality, what is going on is that there is a procedural rigmarole, a serious bottleneck in our Indian judiciary system. What is that procedural rigmarole? You know very well that procedural rigmarole means investigation, or to decide a case, number of things are there before that. First investigation, charge sheet, filing of charge sheet, trial, examination, re-examination, cross-examination, presentation of evidences, presentation of witnesses. So they demand a lot of time also at the same time. It will take a lot of time to deliver the justice. So justice delayed is justice denied, no doubt about it. So that is the serious bottleneck in our judicial system, this procedural rigmarole. Because of that, justice will be delayed and delayed, as in the case of the sensitive Delhi case, the state of the Chhattisgarh case, which was decided on September 9th of this year. And because of that, Allahabad High Court, regarding 498A case, gave directions to all the lower courts. See, don't go very fast with regard to 498A case, because 498 section has been misused, exploited by many people in almost all the courts of law in our country. So you have to exercise your judicious display of legal learning while deciding the case, while taking the case for trial also even. So in regarding 498A, what you have to do is that you should not register the case immediately. No question of FIR immediately. Study the case thoroughly. After a long time, after observing all the ins and outs of the case, then only FIR is to be filed. Trial must be carried out. So the persons involved in 498 should not be taken to task unnecessarily by following this due process of law, because justice must be fair. Justice should aim at righteous life. It should not harm anybody else. So this is what Allahabad Court has given direction, and Supreme Court went to the extent of giving directions to almost all apex courts in our country, all state high courts in our country. Follow the guidelines issued by Allahabad High Court is a really great thing. And in order to achieve this DPL, many great legendaries like Ramjit Malani, Mukul Rahadgi, Dr. Subramaniam, Chidambaram, these great Rohinton, these great luminaries, just they go deep into the layers of law, ocean of laws, only to find an outlets from due process of law. And they have given a number of solutions to so many hundreds of litigations. Well, you can understand, I think you have understood what is the difference between due process of law and this procedure established by law. Right, thank you.